Good evening, this is John Milburn for Laws 13010 Evidence and Proof. We're into week 12 of term 1, 2018. And this week we're dealing with two issues. The first is criminal procedure and evidence, and the second is some commentary about the examination. So let's deal firstly with criminal procedure. There is no prescribed reading in the material as such in your textbook. So I've selected a few important aspects of criminal law, evidence and procedures for consideration. Perhaps if I could invite you to do this. Whenever you're dealing with issues to do with evidence in the criminal law sphere, the first thing to think about, I think always, is Section 130 of the Evidence Act, Queensland. So what's Section 130? Well, Section 130 reflects the Christie principle, but it's a very short but powerful provision. It talks about the rejection of evidence in criminal proceedings, and it reads this: nothing in this Act derogates from the power of the court in a criminal proceeding to exclude evidence if the court is satisfied that it would be unfair to the person charged to admit that evidence. And that's it. That's the entire section. So the reason that's so powerful is that you can apply that in a whole range of circumstances. So if you're, for example, acting for defence and it's a criminal procedure, you're concerned about some evidence, you can't quite earmark how it's improper, then you can always argue the overriding discretion of the court to exclude on the basis that the court would be satisfied it's unfair the person charged to admit that evidence. So that's a good catch-all. When it comes to criminal matters and evidence against an accused person, probably the most damning evidence of all is confessional or admission evidence. And lawyers are often find themselves in a situation of having to argue either as a prosecutor for the admission of confessional or admission evidence as an exception to the rule against hearsay, or on the side of defence to argue that certain confessional evidence should not be admitted. Now, you're probably aware, if you've done criminal law, of the voir dire process. In a jury trial, issues to do with the admissibility of evidence are dealt with separately to the jury. We call it a voir dire situation, or more likely it's a preliminary hearing under Section 590, capital A, of the Criminal Code. So think about the procedure as much as the substantive law when it comes to dealing with the admission of evidence in criminal proceedings. So let's think about confessional evidence in the context of the case against an accused person. If we're dealing with the Commonwealth legislation, the Evidence Act 1995, Commonwealth, the first thing to consider there would be Section 81. We also call the Commonwealth Evidence Act the Uniform Evidence Act. And Section 81, which applies in Commonwealth criminal law proceedings, deals with hearsay and opinion rules, the exception for admissions and related representations. And it's even got an example there. We dealt with that briefly in the past. Offerings of units, lectures in this unit. So admissions and confessions are very powerful. Think about Section 81 of the Uniform Act. Other than that, at common law, I think the starting point is a High Court decision in Pollard. So Pollard against the Crown, 1992, 176 CLR. And here's what the High Court had to say. At common law, before a confession or admission by an accused person is admissible in evidence, the prosecution must establish on the balance of probabilities that it was voluntary. The case that the High Court referred to is Cleland, C-L-E-L-A-N-D, against the Crown, 1982, 151 CLR1. Even if it was voluntary, the trial judge has a discretion to exclude it. There we go again. That's Christie, that's section 130. If it would be unfair to the accused to admit it into evidence. In addition to that, the trial judge has a discretion to exclude such evidence on the ground of public policy, evidence which has been improperly or illegally obtained. And in that context, we're talking about the Crown against Lee, 1950, 82, CLR 133, and Bunning and Cross, which is 1958, 141, CLR 54, and also Cleveland itself. So what we're saying is this. At common law, I think the appropriate starting point when considering the admissibility of confessional evidence would be Pollard. But how do we apply this Pollard test in practice? Well, let's go through some basic steps. The first is, you've got to ask yourself, did the party make an admission or a confession? Usually that's fairly obvious, but it may not be. And sometimes it's important that you listen to the actual transcript or the actual recording, because a written transcript can sometimes be misleading. I mean, for example, to take a simple case, and this is in the question, did the party actually make an admission? If you read a transcript, they may say, the police, are you guilty of the offence? Defendant, yes, I'm guilty of the offence. If you listen to the recording, it might be, police, are you guilty of the offence? Defendant, slurred voice, hang on, turn down the music, turn down the music. Yeah, am I guilty of the offence? Yeah, of course I'm guilty of the offence. As if the person really wasn't. So the context, the tone, the manner of delivery all go to the question, did the party actually make an admission? So that's number one. That's the first thing we need to consider. The second thing is, all right, did the party make the admission voluntarily? To do that, we need to consider, firstly, whether the admission was obtained by conduct that might be regarded as oppressive. If the answer is yes, it was oppressive conduct that led to the admission or the confession, then on the face of it, we would say that the admission or confession is not admissible. And secondly, the corollary of that is whether the admission was obtained by an inducement. If the answer is yes, it was an inducement, then it's not admissible. Now, there's a whole lot of things that might lead to one concluding that an admission was made by an inducement. And it might be as simple as a person being offered an opportunity to have a smoke and a break from the watch house if they're willing to fess up. So you need to look carefully at the circumstances that led to the party making the admission, because what might be regarded as an inducement on the outside, may not be an inducement on the outside, might be regarded as an inducement if the person is in custody. All right, so if the admission was voluntary, in other words, it wasn't obtained because of oppressive conduct or inducement, then on its face, it's admissible. However, we don't stop there. We go to the third phase, and the third phase is essentially to consider the voluntary nature or otherwise of the confession, which is really getting into the judge's discretion in terms of decision making. So if the admission was voluntary, the judge might still exclude it. Now, we've talked about the Christie direction. We've talked about section 130, but there are two other things that you need to consider. The first is the fairness discretion, and the second is the public policy discretion. So If the court concludes that it's simply not fair, it can exclude the admission, or if it's based on public policy discretion, it can exclude the admission. Now, if neither of those favour the exclusion of the admission, it is admissible, but even then there is an overriding discretion. And that overriding discretion is the Christie discretion to exclude evidence. And the basic test is this. So this is what you need to keep up your sleeve and have immediately available if questioned by a judge as to why the judge should accept your submission based on section 130 for evidence to be excluded on the basis that it's within the, use the wording of the section, it should be excluded because it would be unfair to the person charged to admit that evidence. Why, Ms. Forsyth? Why, Ms. Pam? Should I exercise a discretion to exclude the evidence? Why should I be satisfied that it's unfair to the person charged to admit that evidence? The first answer you should consider is the prejudicial impact is greater than its probative of value. And that's Swaffield. So remember the Swaffield case, R against Swaffield 1998, 192 CLR 159. So take from that that if you're going to challenge the evidence, firstly think about section 130, the Christie discretion generally, then think about Pollard, and when challenged as to why the court should ultimately refuse to admit the offending evidence, consider the prejudicial impact as being greater than the probative value. Okay, so that's for confessional evidence and for evidence relating to admissions. There are some other things that I want to touch on tonight. To some degree, we've dealt with these already during the unit, but I think we need to consider them. Actually, before I do, just some other points on, that question of did the party actually make an admission? To be admitted, it needs to be relevant. And just remember, of course, that it is not an admission to remain silent when questioned about something. In other words, people are perfectly entitled to refuse to make no comment, to exercise their right to remain silent. In that regard, think about R against Ireland, the Crown against Ireland, 1970 126 CLR 321. In that case, the High Court considered the admissibility of questions and responses, and in simple terms, it came down to this. From that case, the court said that a failure to respond to police questioning in a formal interview is not evidence of an admission. It's not probative of any relevant fact or circumstance. And that public policy aspect comes through in the Evidence Act. Have a look at section 10, as I recall, of the Evidence Act. This is Queensland. Yep, so section 10 of the Queensland Act says, nothing in this act shall render any person compellable to answer any question tending to criminate the person. It goes on with the rider and says, however, in a criminal proceeding where a person charged does give evidence, the person's liability to answer any such question shall be governed by section 15, which basically establishes the rules in those circumstances. Okay, so the right to silence is embedded in the Evidence Act. Also consider, in terms of public policy particularly, section 10 of the Criminal Law Amendment Act 1894. The section 10 of the Criminal Law Amendment Act 1894, which provides that no confession shall be received into evidence if induced by threat or promise by a person in authority. Every confession made after such threat or promise is deemed to have been induced unless the contrary is shown. and I think I've mentioned previously in this unit, you'll hear that in court for a self-representing defendant who makes a plea of guilty, a magistrate or a judge will routinely ask that person whether they wish to make the plea of guilty of their own free will and whether they are making the plea of guilty without any having been induced by a threat or promise by a person in authority to do so. Just a quick mention on the right to silence. I mentioned the right to silence. Speaking of the Police Powers and Responsibilities Act, have a look at section 397, which states that no person is legally obliged to answer any question put to them, except required by statute. So the PPRA, section 397, works in conjunction with section 10 of the Evidence Act in terms of recognising the right to silence. And as I mentioned, Swaffield is the case where the court will say that mere silence is not a sign of guilt. And Justice Kirby in that case had a few things to say, because if people don't respond to something which is said to them, it might be for some reason other than they're guilty. It might be that they're emotional, they're upset, they're confused, they're reluctant to disclose an alibi because it might be embarrassing. There might be lack of communication skills, legal advice, a suspicion of police, and that might be even more so in terms of issues to do with culture or race. So that's a brief overview in relation to issues about confessions and admissions, the right to silence generally, and when those matters can be raised and when they're not raised. The two other substantive areas that I want to talk about tonight are two rules relating to the drawing of inferences. So in a trial, in criminal law and civil law, it may be at times that the arbiter of fact is invited to draw an inference from something presented in the evidence. And there are two main rules of practice and procedure that really crop up in terms of requests for inferences to be drawn. So when I talk about an inference being drawn, I'm talking about someone taking perhaps a logical next step to say, well, because this occurred, then I'm entitled to infer something else. Or, and this is where it's important, because something didn't occur, I'm entitled to infer something. Now, we've already said, simply because a person refuses to say, I'm not guilty, or I'm guilty as the case may be, there is no basis because of that mere silence for a jury to properly infer that the person must be guilty. And we get round that by judges making very clear statements to juries that every person is entitled to silence, etc. So they can't make that inference. Whether they do or not is a different thing, but they can't make that inference. So I'm talking about two other types of inferences that we commonly consider in litigation, both in criminal law and civil law. These are the rule in Brown and Dunn and the rule in, do either of you know the other rule? They work together. We talk about the rule in Brown and Dunn, and the other rule relating to inferences is the rule in, it's another case, no, Jones and Dunkel. So these two, think about these, the rule in Brown and Dunn, the rule in Jones and Dunkel. We'll just deal with both of them quickly. Firstly, the rule in Brown and Dunn. Okay, so Brown and Dunn's important. It's very important in civil law cases, not so much in crime. And the reason that I'm raising this, particularly in the context of criminal evidentiary procedure, is to highlight that this is a major difference between practice in civil and practice in crime. So what's the rule in Brown and Dunn? Basically, it comes down to this. A person who is exercising cross-examination or who is engaged in the process of cross-examination, generally speaking, according to this rule, has an obligation to put that party's case to the witnesses for the other side, provided, of course, it's an issue where that witness can testify. An example, you're acting as counsel for a defendant in a civil matter, and the evidence that you have would suggest that the expert called by the plaintiff is incorrect in terms of something to do with the facts of the case. If you call your evidence and you raise these issues in circumstances where you then say, because of these things, the court should not give any or much weight to the expert opinion, the plaintiff's lawyer, your opponent, is entitled to say, I object, Your Honour. There's been a failure to comply with the rule in Brown and Dunn, in that if my learned friend wishes to attack the quality of the evidence of my expert, then it was incumbent upon my learned friend during the course of cross-examination of my expert witness to put these matters to the witness, so the witness had an opportunity to comment upon those issues. It's a fairness thing, isn't it? So it's only fair that if you're going to attack the prosecution, if you're going to attack the plaintiff's witness, and I'm talking about a civil matter now, because you've got other evidence that will contradict or colour what they're going to say, you've got to let them know about it. It's only fair to give them a chance to respond to it. So it's a rule that's based on procedural fairness. You might let your opponent know well in advance through prior notice or some sort of admission or agreed fact as to what you're going to do, but you generally have to put it. So I know that I'm not talking specifically about crime just yet. I'm really talking about civil, but there is a case that you do need to consider. It's a New South Wales case from 1983, and it's called Allied Pastoral Holdings against the Federal Commissioner of Taxation. It's 1983, 1 New South Wales Law Reports 1, and that's at page 16. Now, in that case, Justice Hunt at 2223 said there are basically 3 reasons why we have this rule. I'll just pause for a moment to get you to think about why we would have this rule. The rule is, if you're going to cross-examine and you're going to call witnesses later that would have the effect of colouring or minimising the quality of that evidence, you've got to put this to them. Number 1, it gives the witness an opportunity to deny the challenge on oath or defend a position under attack. So if your evidence as a defendant is going to attack the quality of the evidence of the witness for the plaintiff, give them a chance to defend themselves or defend their position. That's number 1. Number 2, it gives the party calling the witness an opportunity to call corroborative evidence which might otherwise not be called. So if you're going to attack the witness evidence, give your opponent a chance to call other evidence to corroborate what they're saying. That's the second thing. And the third thing is it gives the witness an opportunity to explain or qualify their own evidence in light of this contradiction that we know is coming. So in Allied, Hunt J provides these reasons as good reasons why we have this rule in the first place. Now that's for civil. Crime, not so much, is the short answer. There's a Western Australian decision of K against Western Australia. It's 2010 WASCA 157. Bus JA said the rule must be applied in criminal proceedings with care and circumspection. This is important because there are different consequences. In that case, they referred to a High Court decision from 2005. This is a pretty important one. It's MWJ against the Queen, 2005 HCA 74. And what's the rationale as to why this is the rule in Brown and Dunn is not so important when it comes to criminal proceedings? I guess it's fairly obvious when you think about it. It's because in a criminal proceeding, an accused person bears no burden of proof, which you can't equate that to the position of a defendant in a civil proceedings. So the rule in Brown and Dunn can't be applied in criminal proceedings, or if it is applied, there are serious qualifications. And it's a bit like the rule in Jones and Dunkel that we'll get to shortly. So, but if there is a breach of the rule in Brown and Dunn, what are some of the things that can be done about it? Well, number one, the witness can be recalled to have that chance. Number two, the court can give directions to a jury. Number three, the court can impose restrictions on what might be said when addressing a jury. And number four, the calling of the witness may be precluded. In other words, you can't call this witness. They're the potential ramifications of a breach of the rule in Brown and Dunn. Have a look at, on the first of those, the witness being recalled. In the Commonwealth sphere, Evidence Act 1995, have a look at Section 46, which provides that there is the opportunity to give leave to recall witnesses if there is a breach of the rule in Brown and Dunn. Okay, so these things, the rule in Brown and Dunn applies very much in civil matters, and it can apply selectively in criminal proceedings. If you're really stuck for an explanation about how this rule works, can you think of in a criminal sphere, can you think of a great place to look for guidance as to the effect of the rule in Brown and Dunn in criminal law proceedings in Queensland? Where's one of the first places you should look for expert guidance? Now you might say legislation, but you'll note that I haven't referred you to any legislation.
Is it the bench books?
Yes, that's it, Vivian, you got it. So the bench book's always a great resource. So for the examination purposes, you would really want to have either the bench books or you printed or extracts of the bench books available for you to prepare your answer. The bench book numbers change, so be aware that the number does change from time to time. At the moment, Rule 32 in the bench books deals with the rule in Brown and Dunn. Okay, let's have a look at the other rule relating to drawing of inferences. That is the rule in Jones and Dunkel. I'm going to quote something from Cross on Evidence, which is a very authoritative textbook. And it says at 12:15, the rule operates where there is an unexplained failure by a party to give evidence, to call witnesses, or tender documents or other evidence. In appropriate circumstances, this may lead to an inference that the uncalled evidence would not have assisted the party. However, the rule is complex, and unless the appropriate circumstances are present, the court will not be bound to draw the adverse inference. Moreover, if the inference is drawn, the rule cannot be used to fill gaps in the evidence or to connect conjecture into suspicion. So what does all that mean? So what we're really saying is, if a party does not call a witness and you would have expected that they would do that, then the rule in Jones and Dunkel says that the arbiter of fact can draw an adverse inference against that party due to their failure to call the witness. So, I don't know, in a civil matter, if there is a case involving a debt and it becomes clear that the argument is about whether this oral contract exists or otherwise, and the defendant says there is no oral contract, there was never any oral contract made, and they go in the witness box and they say something like, and while I was there involved in this conversation, my mother was present and heard everything that was said. Well, you might expect the defendant would call his or her mother to give evidence to say, I was there, I heard it all, there was no talk about a contract during that discussion. If the defendant chooses not to call mum to give evidence to that effect, is the plaintiff entitled to say, Your Honour, adopting the rule in Jones and Dunkel, I invite you to draw an adverse inference against the defendant. The inference is that the failure to call mum is because mum's evidence wouldn't have actually helped the defendant at all. So I'm asking you to draw that inference. Does that make sense? Remember what Jones and Dunkel was all about? It was an accident. It was a car accident. This was from 1959 from memory. Car accident, and the defendant didn't give any evidence. And there was only, really the only person who actually knew what happened was the defendant. The defendant didn't give evidence, and the High Court basically said, yeah, you can draw an adverse inference in those circumstances. Now, that's kind of the basic rule. So what are the three conditions that apply for the rule to be applied? And I'm really talking about civil cases now. What are the three conditions? Number one is whether the uncalled witness would be expected to be called by one party rather than the other. So in the case of a contract dispute between A and B, and the key witness is B's mum, who would you expect would call B's mum? You'd expect B to do that, wouldn't you? So number one is not as though we're talking about potentially a neutral situation. We're talking one party. You would expect one party clearly to call this witness rather than the other one. That's the first condition of Jones and Dunkel. The second is whether in fact the evidence of this missing person would help to elucidate the matter. And number three, whether this witness's absence is unexplained. I mean, if the evidence is that mum is currently, exploring Antarctica and out of reach, well, at least there's an explanation, isn't there? But if the evidence is, well, mum's, at home, probably making a cup of tea, and she lives 2 minutes away from the courthouse, not so much. All right. So in criminal law proceedings, the rule in Jones and Dunkel is either, depending on which commentator you read, it's no longer appropriate, or it's appropriate but only in certain circumstances. Again, no prizes for knowing the place I reckon you should look for the purposes of an exam, if there is an exam question on Jones and Dunkel. And I'd suggest to you there's a very good chance there'll either be a question on Brown and Dunn or Jones and Dunkel. Probably not both. But bench books, number 31. Have a look at that. I'll read from the bench book, and this is what it says a court would say. That is, if the defence or even prosecution fail to call a material witness. It may appear to you that witnesses other than those who have been given evidence might have been able to give some relevant evidence on some aspect of the case, but you may not speculate as to what those others who were not called might have said had they been called. You should act on the basis of the evidence that has been called and only that evidence. So you can see that the courts in criminal proceedings basically say, look at the evidence that you have. Don't be tempted to draw inferences as a result of evidence that you don't have, even if you might have expected it. to be available. And the authority for that is Dyers against the Queen, High Court decision. So we take from that whilst there may have been a time where it was appropriate to do so, it is now no longer appropriate for a Jones and Dunkel type direction to be given, at least in relation to the failure of defence to call witnesses. You might recall there was this, if you like, this different approach between the Weissensteiner case and the as a party case. Do you remember that? And Weissensteiner, I remember, was a case with two people in a fishing boat. One of them disappeared. The guy came back. I haven't got my mate with me. He's not here. Said nothing. I was saying, well, really, you should know what happened to him. You're on a charge of murder and you're not going to say anything. So the court in that instance, in a sort of a Jones and Dunkel type approach, sorry, too much talking, said you can draw the adverse inference. As opposed to as a party, where they said the jury should not draw an adverse inference in many other circumstances. So when we're talking about Jones and Dunkel, think about the general policy, think about the bench books, the conditions that might apply for it to be applicable in civil cases, but understand the difference between the way in which it might be applied in civil cases as opposed to criminal law cases. And if you're dealing with a question on Jones and Dunkel in the criminal law sphere, think about the bench books and then think about Weissensteiner and as a party. Probably the only other case that you might want to consider is RPS against the Queen. So they're the cases that and the resources that you might want to consider. The only other thing is, again, I did mention Section 46 in the Commonwealth sphere, and that to some degree has some rule. All right, so I mentioned RPS against the Queen. That case is 2000 199 CLR 620, and in that case, the High Court said, not only is an accused person not bound to give evidence, it is for the prosecution to prove its case beyond reasonable doubt, and the observations by the court in Jones and Dunkel must not be applied in criminal cases without taking account those considerations. So the RPS decision reflects what's in the bench books and reflects the approach adopted by courts now, but consider the as a party situation as well, and consider the Weissensteiner against the Queen. All right, you've been very patient, you've been very good. Are there any questions about what we've discussed tonight in the context of criminal practice? All good? All right, thank you. Look, let's talk about the exam. So, as you know, the examination comprises of 8 questions. You might recall that and I think I did this, I usually say, just remember to look at the first word, usually of an exam question, because it gives you a very clear idea of what your examiner seeks from you. Because the word might be interpret, analyse, evaluate, infer, explain. Just as a refresher, interpretation means determining the material facts. Analysis means your ability to identify hidden features. Evaluation means your ability to assess. Explanation means your ability to communicate results. There is another one, self-regulation, which is your ability to apply other skills to your own thinking. So what do we have in the examination? Well, if you look at the first word in 5 questions out of 8, it's none of those. The first word in 5 of the questions is what. 2 of them commence with the word explain, and 1 of them commences with the words in Queensland is ... So what do we infer from that? For examination purposes, please read the word what as if it was explain. So we've got a really skewed examination for you. Skewed in the sense that I'm not asking you to interpret, I'm not asking you to analyse, I'm not asking you to evaluate, I'm not asking you to infer. Really all I'm doing in almost the entire examination is to explain. And when you see the word explain, it's an absolute hallmark of an essay-style question. So you can be satisfied that this is not a problem-solving examination in any sense. See, the first 2 lots of assessment you did were very much problem-solving issues. Now you have your chance for a good old-fashioned essay-style explanation. So, it might be explain the rule in Brown and Dunn, explain the rule in Jones and Dunkel, things like that. So it's not that basic, but you get the idea. And you can look at past examinations to give you a very clear idea of the sort of questions that I'm going to ask you, almost the same style questions, and they're really simple questions. So it's not as though there are things that are missing, but they're very straightforward in that sense. Now, Sam, did you have a question?
Yes, I was just wondering if you're allowed to tell us what the rough word count or expectation is on the 8 questions.
That's a really good question, and the answer is there is no specific word count, and I'm not even sure I could guess as to what would be an appropriate one. What I would urge you to do, though, is to prepare model answers, or at least point form as much as you can, and then fill it in from there. If you're going to add, if you're going to value add, feel free to do it, but do so carefully so that we're not way off topic. But if it's pretty close to the topic and you've got some time, then you can add to it, you can contribute, and that might just help to get a few more extra marks. The risk, though, is if you add, sometimes you can make a mistake and you can actually have marks taken away from you because you've added something that's incorrect or doesn't value add. So I'm sorry that's not an answer to your question, Sam, but I think it's pretty obvious normally. Those that have prepared well for an invigilated examination, leaving aside issues to do with how quickly you can write, usually have something that is very neat. They've actually got headings, they've left a bit of space, and they don't have huge chunks where they've written something and then crossed it out, and it's orderly. The other hallmark of someone who's well organised is that they're, and how many times, and you know that I'm going to say this because I say it all the time, typically they write with short sentences, typically they write in the active voice. So for those people that aren't well prepared in an examination, often I'll see long rambling sentences where they're developing an idea and they think of something else and they keep writing, then they come back to the original idea and then they go off somewhere else to the point where it's not cohesive, it doesn't make good sense. So if in doubt, short sentences, active voice helps to convey the point that you wish to make easily. So that was completely non-response to your question, Samantha. My apologies. All right, so where do you think the questions might come from? Well, theoretically across all of the course, but I'll mention a few things you might expect, well, there's a list of about 12 things here, questions to do with admissibility, the methods of proof, circumstantial evidence, identification evidence, hearsay evidence, then exceptions to the hearsay rule, defendants who choose to testify, defendants who confess, similar fact and propensity evidence, documentary evidence, expert evidence, opinion evidence, and examination of witnesses. I know what you're going to say. Well, that covers everything. Sorry, Vivian. It's pretty broad. It's pretty broad. You were hoping for something really specific there, weren't you? I should add to that, based on what I've said tonight, the rule in Brown and Dunn or the rule in Jones and Dunkel. It'll be, well, one of those two will be on there, I'm sure. Okay. Any questions then about the examination or anything to do with the unit, because we're just about to wrap up? Vivian, did you have a question?
Yeah, so last week you said we could come in with the materials that were allowed. So the Evidence Act, 1977, Queensland. Can we come in with Barristers Rules, Queensland, Australian Solicitors Conduct Rules, Uniform Evidence Act?
Absolutely.
Okay.
All of those things you can bring in.
Oh, okay.
In fact, as a general rule, the only thing that you can't bring in is something that will allow you access to the internet.
All right.
So it's basically paper. Now, if you bring in a lot of material, you'll probably struggle because you won't have time to research it all. But be selective. And if you think that you have a good idea of what questions might be on the examination, for example, I've mentioned circumstantial evidence. This is not a special hint, just the first one that comes to mind. You might think circumstantial evidence, and you might have a dot point of 8 things or pieces of legislation or cases or whatever it might be that you think, I must remember to get that down. See, back in the days when I did exams in the late 70s and early 80s, mostly the late 70s, it was all completely closed book. So, I had to use mnemonics. So if I wanted to remember 8 things about circumstantial evidence, I would write them down. I'd select a letter, typically the first letter of each sentence, and I would then make it into some form of mnemonic. You know what I mean by mnemonic? So, poor elephants climbing vines get suddenly frightened. Have a look at South America, the countries, and you'll see what I mean by that. So, that type of mnemonic is what we used to have to do. You don't have to do that now. You can write it down, have your dot points, and at least that way you cover those points. So you can do that. You can write full answers. You can take all that in, Vivian. So you don't have to rely on the source material. You can rely on your own notes, the notes that you've prepared, the dot points or the actual full text. You can write the whole answer and rewrite it in the exam if you want to. I hope that clarifies it. Any other questions? Yes, Sam?
Put my actual hand up, sorry. In your document around the exam advice on the system, it does say that the exam's worth 50%, but our course information says it really works out to 40. So is it 50 or 40?
It is. It's 40. Sorry, it is 40%. We've already had 30 for the cross-examination or the examination in chief exercise, and we've had 30 for the experiential exercise. It is 40, and I know that it's 40 because we've got 8 questions worth 5 marks each. So excuse my maths, but it is worth 40. Sorry, but thank you, Sam. Thank you for raising that. I know what I've done. I've got another unit, and I must have done the other unit first, and I've made the mistake of copying over rather than starting from scratch, which is a rookie error. Don't do that. So, but thank you. All right, any other questions? I've got a request. I suspect you've both done this, but it's very important for the university. It's very important for me that people do have their say. So please, if you haven't already done so, go onto the landing page for Moodle, go to the top left-hand corner, click the big red button, have your say. Time is running out. It won't be there for much longer. Have your say. It's all anonymous, but I'd really appreciate it. Okay. And Sam said, didn't take long at all, so that's good, thank you. All right, well, really appreciate your attendance. Thank you for joining us, Vivian and Sam, as you've done pretty much all term. Good luck with the examination. I'm sure you'll do well. Those of you that are watching this recorded session, thank you so much for your attendance in Evidence and Proof this year, and all the best for the exam. Finally, if there are any questions, please, UCrew. If you haven't been on UCrew now, there's some very good material right now, as from today, about the exam. So go to UCrew. Okay, all the best. See you then.